The meeting of the Michigan State Board of Canvassers is in session at 10:01. Good morning. We're going to start this morning with public comment. If you are an attorney speaking for public comment, because I noticed, and I have to tell you, almost everybody here this morning is attorney speaking. If you're an attorney speaking for public comment, you have 5 minutes. I would say we would start with Mr. Ziegler.
Thank you, Mr. Chairman. My name is Dan Ziegler with the law firm Dickinson Wright, here on behalf of the Coalition to to stop the business and family tax hike and John and Jane Doe. My associate, Mr. Charlie Spies, and I sent a letter to the board making 5 points and requesting that the board rescind its prior approval of the Invest in MI Kids petition summary on June 27, 2025. I wanted to come here, just talk about 3 of those points very briefly, maybe put an additional coloring on one of them, and then ask the board to rescind its approval. So the first point is about the switched petitions. And to understand the gravity of the switch petitions, I think we have to go back to how this process is supposed to work. How it is supposed to work is a petition proponent submits a petition to the Bureau of Elections. The Bureau of Elections requests public comment. The Bureau of Elections and the acting director of elections then takes the petition, the public comments received, and drafts a 100-word summary that he presents to the board. The board then hears additional public comments at the meeting and then tweaks the 100-word summary to be accurate and approves it. And almost none of that happened with respect to the Invest in MI Kids petition, partly because they swapped it out. The Invest in MI Kids petition filed a petition with the Bureau of Elections. 7 hours before public comment closed, they filed an amended petition which substantively changed what their petition would do in 2 areas. They thus evaded public comment. They also did not alert the deputy director, now acting director of elections Fracassi, about the change. And we know that because acting director Fracassi based his summary and his analysis on the first version of the amendment, not the second version. Invest in MI Kids, therefore, this board therefore considered a 100-word summary that did not receive public comment and was based off the wrong petition. At the meeting, there was then no public comment. So this petition did not receive public comment either on the front end or the back end, and it did not receive accurate analysis by the Director of Elections. For that reason alone, we'd request that the board rescind its approval of the 100-word summary and reset it for a future meeting's consideration. A second and sort of related point is the Open Meetings Act violation that occurred at the last meeting. The board was in a rush and it was in a hurry to finish a very lengthy agenda. And in its haste, it did not allow individuals who had submitted a valid piece of paper requesting to speak on an agenda item. And that is an open and shut case, or an open and shut violation of the Open Meetings Act. This board thrives and lives on openness and transparency. And by not allowing public comment on the Invest in MI Kids petition, it violated that duty of openness and transparency. For that reason, too, we would ask that this board rescind its approval of the 100-word summary and reset it for public comment, both on the front end and the back end. The final issue I want to discuss is just the preparation of the 100-word summary. I see that Deputy Director Fracassi is now Acting Director Fracassi, and that's very good, because as Acting Director Fracassi, he is now empowered to prepare 100-word summaries for this board's review. But at the last meeting, looking at the agenda and reviewing the transcript, the discussion between Mr. Doster and Mr. Fracassi, it's clear that he was not the acting director. He was the deputy director. And that's a problem because it runs headlong into a Michigan Supreme Court case, which is 361 Mich 150, Detroit Edison Company v. Michigan Corporation and Securities Commission. And that case is interesting because in that case, 3 entities, the Assistant Attorney General, the Deputy State Treasurer, and the Deputy Auditor General, sat on a committee. But the committee required that the Auditor General, the State Treasurer, and the Attorney General sit on the committee. And the court invalidated and held that that committee's decisions were null and void because no statute explicitly allowed the Auditor General or the State Treasurer to appoint a deputy to sit at that meeting. By considering the 100-word petition prepared by the deputy and not the acting director, the board did not comply with the mandates of MCL 168.4A2B, and we would ask that the board rescind its purported approval of the 100-word summary and reset it for public comment. The final point I just want to make is that this is more so on the swapped petitions issue again. That I see in the room, we have Mr. Doster, we have Mr. Brewer. I don't see Mr. Lydell, but Mr. Spies is aware of this issue. The board prides itself on being a board of precedent. There's one rule, it applies to everyone. And if the board holds today that a petition proponent may submit a petition and then 7 hours before public comment closes, and without alerting the Director of Elections, swap the petition, that's something that all the lawyers will take notice of, and that's going to be a precedent going forward.
Thank you, sir. All set? Mr. Doster?
Sure, guys, have to put this down a little bit. Good morning, Mr. Chairman, members of the board. Eric Doster on behalf of Small Business for a Better Michigan. When I first walked into the last canvassers meeting on June 27th, here's what I knew. On June 10, the announcement went out that Invest in My Kids filed their petition. On June 17th, this was the deadline for public comment on the petition summary language for this petition. On June 23, the Deputy Director released draft summary language using the phrase, quote, local public school district classrooms, end of quotes, as where the funds were to be spent from this new proposed tax. Then on June 27th, the Board of State Canvassers hearing began at 9 a.m. And the YouTube video of this Board of State Canvassers hearing is available online. The hearing on the Invest in My Kids matter began at around the 6-hour, 3-minute, 50-second mark of the YouTube video. At the 6-hour, 7-minute, 48-second mark of the YouTube video, Mr. Fracassi was referring to his draft language before the board and again used the phrase, and I quote, local public school district classrooms, close quotes, as where the funds were to be spent from this new proposed tax. At the 7-hour, 10-minute mark, for the first time in these proceedings, Mr. Liedl, representing Invest in My Kids, indicated that this proposal now omits the word public. With this revelation, it was clear from not only my reaction, but the reactions from this board that no one knew about this switch. And of course, we have just a few minutes earlier, Mr. Fracassi using the word public to address the board. So now that we've had the opportunity to go back and attempt to unravel what actually happened and why everyone, well, almost everyone, was talking about the petition that was attached to the June 10th announcement, which is not the petition before the board on form today, 2 points scream out. First, if this board does not do anything in everything in its power to correct this situation, is this the precedent that the board wants to have going forward? How can this board allow a public announcement to go out on a proposal and then either right before or right after the expiration of the public comment period, allow the petition sponsor to make substantive changes and go forward as if nothing happened? And make no mistake, this was a significant change that was made to the Invest in My Kids proposal. In my public comments submitted to this board by the June 17th deadline, I commented about this exclusivity with aspect to this the use of the word public school districts. But more importantly, if this were not a substantive change, then why did Invest in My Kids make this change in the first place? Of course these changes are significant. That's why they made them. Actions speak louder than any after-the-fact denial. To allow this type of situation to go unchecked is not the precedent that this board should tolerate going forward. And speaking of precedent, in a May 31, 2024 order, the Michigan Supreme Court upheld this board's determination in one of the raise the wage cases where the petition sponsor changed the substance of its proposal so that it was different than that proposal originally submitted to and approved by the board. In that case, the court determined that this board did not have a clear legal duty to later certify a petition, the substance of which had changed. The second point that screams out here is different. At the 7-hour, 23-minute, and 10-second mark of the June 27th hearing, Mr. Liedl says that they advised the Bureau that the initial petition, which was attached to the June 10 announcement that started these proceedings, was, and I quote, withdrawn, end of quote. Quite simply, when a petition is withdrawn, the process stops. I have withdrawn at least 3 or 4 statewide petitions, all of which were before this board for final certification, which is well beyond where we are here today. And the process stopped right at that moment. Over the years, we have witnessed petition sponsors appear before this board and withdraw their petitions right before this board at a hearing. They are well within their rights to do so, and they always have the opportunity to resubmit. In the present situation, if I may just have a few more minutes, Mr. Chair? One? Okay. In the present situation, when the initial petition withdrawn by Invest in My Kids, the process stopped right then and there. And the sponsor was allowed then to submit its new petition, which is certainly in their right to do so. So, to summarize, I urge this board to do everything within its power to remove the dark clouds that have formed over the Invest in My Kids petitions, to the extent that any protection they think they may have by participating in this optional process is simply non-existent based on the present circumstances. 3 things. This board should seek an unequivocal Attorney General opinion about the propriety to approve a petition summary that was not first prepared by the Director of Elections, as I already talked about at the June 27th hearing. Second, this board should protect the integrity of this process by not allowing a public announcement to go out on a proposal and either right before or right after the expiration of the public comment period, allow the petition sponsor to make substantive changes and go forward as if nothing happened. And finally, this board must recognize that when a petition is withdrawn, the process stops right then and there until the sponsor submits a new petition to start the process again, which is certainly within their right to do so. And I appreciate the time and welcome any questions the board may have.
Thank you very much, Mr. Dosser.
Thank you.
There are no more slips for general comment. I'm actually going to move on and ask for, do you? Well, I was going to call you out anyway because I noticed that you have yourself set up to speak to item 4, which I don't think is the item you're actually after. But so here's your option. You can speak in the general comment, and I'll give you 5 minutes. But then you're giving up your 5 minutes if you want to speak to 3. You asked to speak for.
Please, thank you.
There we go. You have to turn on the microphone.
Sorry, can you please repeat your question?
The issue is you asked to speak on 4, but I think you wanted to speak on 3.
Yes.
If you would like to speak in general comments instead of speaking on 3.
If the board plans to take action with regard to the relief requested by either commenter, I would request to be able to
I will
speak
give you an opportunity to speak before anything happens with
in that
item 3.
action.
How's that?
Yeah, in regard to sort of these generalized comments, I would reserve my 5 minutes to actually speak on the open agenda item number 3.
Then you would speak on item number 3. Is that what I hear you saying?
Yes.
So then we're going to go on then with our agenda, and you can come back and speak on 3.
Yep. And then to the extent that any other action happens with regard to the relief requested by either Dickinson or Mr. Doster,
I'm not hearing you, and forgive me. It's my.
Sorry.
It's,
to the extent that any further action happens with regard to the relief requested by Mr. Doster or Dickinson Wright, we would request the ability to engage in that process if there's some sort of supplemental agenda item added that hasn't been reflected in the agenda as drafted.
see what happens.
You might have a different agenda. That's what, I think the
Yeah.
numbers might be different. Which agenda?
Are you,
Yeah, that's what I think. Maybe not.
I just picked up the one today. I did not print
Oh,
a
okay.
different
You have it.
version.
Okay.
It's okay.
That's
I-
fine.
we
Thank
would-
you.
I would have let you know anyway.
Thank you so much. Okay, so I think we're sorted?
Yep.
All right.
See you in a minute.
Thank you.
Thank you.
Moving forward, I'd like a consideration of the minute meetings for the June 27th, 2025 meeting.
So moved.
Moved. You second?
Second.
All in favor?
Aye.
Aye.
Aye. Moving along. We are, Mr. Facese, do I need a motion for the next item here? I need to
Yeah.
describe it first. So, yeah. What we are going to do is, relating to Mr. Spee's letter, the board is going to go into executive session, closed session, and I need a motion to do that.
I move the Board of State Canvassers to go into closed session for the purpose of considering a legal memorandum drafted by the board's attorney, which is exempt from discussion or disclosure by state statute.
Support.
All in favor? No, and we have to do that as a roll call, don't we? Mr. Facese, would you do the
Yes.
roll?
Correct. Chair Housekamp,
Yes.
Member Cummings,
Yes.
Member Cordes.
Yes.
Mr. Chair, you have 3 yeas, 0 nays. The motion to go into closed session passes.
Thank you. We'll be back. Canvassers are back in session. Following the executive session that we just finished, there's an issue that's been raised with the petition for Invest in My Kids being changed and being changed after deadlines. What I'd like to do is to ask Acting Director Fracchesi to put together a timeline for you so that we have that on the record.
Sure. So I'll walk through how it was received with the Bureau, the different deadlines. So the first submission, so Invest in My Kids submitted the request for a constitutional amendment seeking approval as to form and seeking approval for the summary language. That first request was received and put it out for public comment on June 10th. Notably, that at that part, that is a process that the Bureau of Elections typically has done, just as to solicit public comment in order to make a proposed 100 words that is presented to the Board of State Canvassers for approval or rejection. That is something that's not formally done on behalf of the board. That's something that has been traditionally done by the Director of Elections. The Director of Elections has done it this way for quite a bit of time, and I'm saying the director in this context because it dates back multiple directors, and it relates also to summary language that appears on the ballot language. We've traditionally put out public comment to use as we make the recommendation. So that announcement went out on June 10th. The petition at that point that was submitted did contain the words public in it. It said local public schools at that point. Subsequently, another petition was submitted on June 16th. On June 16th, the petition language did change, and the language that was sent, sorry, I'm just pulling up the email. In the email that was sent with us, the former petition on June 10th was withdrawn. The exact language says, I'm just going to read the email. It says, on behalf of our client, Invest in My Kids, attached is a revised petition proposing an amendment to the Constitution. This supersedes the petition submitted on June 4th, 2025. That was received by the Bureau of Elections on June 16th, 2025. Public comment closed on June 17th for the petition that was put out on June 10th. In that June 16th submission, as well as the subsequent June 20th submission, which was the final submission, that petition did not contain the word public. That version of the petition did not go online until June 24th, which was 2 business days following the final submission as required by election law. I think that's pretty much the deadlines as we walk as that we had, not the deadlines, but the calendar of events that went through. So the Bureau of Elections, as I've said repeatedly, we do not look at the language of the petition as part of our review process. That is up to the sponsors of the petition in what they submit. Our review process when we're reviewing for form is solely to look at those mandatory elements. We do not look at the substantive text of the approval of the petition. So that is why it changed, and that's why the Bureau would not have caught that, because that's not part of our review that we do. It's not part of our review because we just we don't have the legal authority to correct or anything like that, to suggest different language or anything like that is what I mean, substantive language. When we're looking at the language on the back of the petition, we're purely looking at, is it the correct size font, things like, correct, I always say that wrong, type size, thank you, and using the appropriate font, the appropriate structure, and things like that. We're not looking at the substance of the petition. So it then became clear at the last meeting that this change occurred, that petition was provided, so both to the public and to the board, but that's kind of the ordering. I don't know if there's any other, I'm happy to answer further questions if we would like, if you would like.
Ms. Cummings, do you have any questions for Mr. Fracassi?
I do not.
Mr. Cordes, do you have any questions for Mr. Fracassi? No. The submission of petitions for everybody is a process that if this were a religious institution, I would call it holy. I don't know what to call it in a civil institution. But that process is something that everybody has to put trust in, and they have to put trust in all the way through, not even just here, but all the way to the ballot box. And we spend a lot of time talking about trust, but much, much more importantly, you folks that are practicing on the bar, and for all of these folks at election, they live trust in the electoral process and in the elections process. And this is just too important to step aside from. And so what I'm going to do is ask for a motion. I'd like a motion to rescind the 100-word summary that we approved, to rescind our approval of the 100-word summary that we made in the meeting of the 27th. And do I have a motion?
I move the Board of State Canvassers rescind its approval of the 100-word summary for Invest in My Kids approved by the board on June 27, 2025. I further move that the board direct staff to commence the summary approval process for the petition submitted by Invest My Kids using a receipt date of July 10, 2025.
Do you have a second?
Yes, I second.
This is the part where we would normally vote. But before we do that, Ms. Flowers, I promised you that I would let you speak. And so I'm going to give you 5 minutes, just like I promised.
I appreciate you following through on that.
You're still going to have to give your name and information.
Perfect. Good morning, Olivia Flower, on behalf of Invest My Kids. With regard to the timeline that Acting Director Fracassi just went through, we generally have the same dates with the exception of that June 4th submission rather than the June 10th submission for our original petition. I would note that to the extent we're talking about the legal standards raised by Mr. Doster and Mr. Ziegler, there's been no violation of the Open Meetings Act. There's been no violation of the procedure for submitting that optional approval as to form. The petition that, and to the extent that there's any harm begotten by that submittal process, it's non-existent. Both petitioners, or both commenters that came before you today were at the last meeting. The reason that we're here today is because it took so long, because we went through and everyone was participating so fully in the actual development of that 100-word statement. That petition was in front of both commenters. To the extent that the word public was removed from the term local public school districts on June 16th, more than 11 days before the actual Board of State Canvassers meeting, the term public local school district doesn't refer to anything in Michigan law. Local school district is how that term appears throughout Michigan state law. So to the extent that they want the opportunity to comment on something that doesn't exist in Michigan law, that doesn't help this board's review or summary of that proposal in any way. The Open Meetings Act allows for the opportunity for the public to review the deliberations of the board on the record. Those deliberations were fulsome and spirited, and everyone commented on the actual form of the petition that was before the board then, is still before the board now. It's the same petition. The board already ruled on this. We believe it's improper to rescind that sort of approval. This optional approval as to form process is something that encourages direct democracy participation, and I think that applicants should have full faith in that process and that it's not going to be pulled out from under them later. So to the extent that this board has any other questions for us with regard to the facts about what happened or our summary of our actual proposal, please feel free to let us know. We're happy and available to answer questions.
Thank you for your comments.
Thank you so much.
With that, I would ask for a vote. Do we want a roll call vote on this?
Sure.
Is that, I'm just waiting for somebody to ask for that. So, Mr. Ricazzi, would you call the roll?
Of course. Chair Housecamp.
Yes.
Member Cummings.
Yes.
Member Cordes.
Yes.
Mr. Chair, you have 3 yeas, 0 nays. The motion passes.
Thank you. In light of the motion that we just passed, item 3, which is the consideration of the form of the constitutional amendment submitted by Invest in Michigan Kids, is no longer relevant for this meeting, and so I am removing that. And we are going to move on to number 4, the consideration of the form of the first constitutional amendment submitted by Americans for Citizens Voting, Michigan. Sir, you have 5 minutes.
Good morning. You're David Porter here on behalf of the American for Citizens Voting Michigan. We have nothing to add on this particular budget item and just ask that the form be approved.
That was easy. Do you folks have any questions, or we have a motion?
I don't have any questions, but you everything good on the form?
Yeah, so just to be clear, this is the first petition that was submitted that the board considered summary language on. I'm blanking on the date all of a sudden of the meeting. I apologize. Not the last meeting, but the one before that. So this is the summary language that the board considered for that. This is approval as to form for that petition. Staff has reviewed it consistently and has determined that it complies with the standards and the requirements.
May 16th.
May 16th, thank you. The meeting that we had on May 16th. It seems so long ago.
I'm good.
I move that the board approve the form of the constitutional amendment submitted by Americans for Citizen Voting Michigan with the understanding that the board's approval does not extend to 1, the substance of the proposal, which appears on the back of the petition, and 2, the manner in which the proposal language is affixed to the petition.
Support.
All in favor?
Aye.
Aye.
Aye. Motion passes. Mr. O'Keefe, you are also on this next item, correct?
That's correct.
So if you would just stay exactly where you are. Item number 5 is a consideration of the 100-word summary of the purpose of the second constitutional amendment sponsored by Americans for Citizens Voting Michigan. The summary, as drafted by the acting director of elections, is as follows. Constitution, is it okay if I read that for you? Of course. Okay, thank you. Constitutional amendment to require the Secretary of State verify and track all voter citizenship through a statewide program, individual document submissions, or during provisional voting. Remove non-citizens after mailed notice, beginning November 2nd, 2027. Prohibit counting ballots from voters with unverified citizenship unless documents shown to election administrator within 6 days post-election. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate the affidavit alternative for voters without photo ID. Require photo ID or driver's license or partial social security number to vote absentee. require state-funded hardship program for obtaining required documents, subject violations to $1,000 fine and/or up to 5 years imprisonment. The word count is exactly 100 words. And with that, Mr. O'Keefe, you have 5 minutes.
David Porter here on behalf of the sponsor, Americans for Citizen Voting Michigan. Sorry about that.
You know what? Forgive me. You know,
I will keep my comments very brief. We thank the board and the acting director for their attention to this matter. Obviously, it's been before the board a few different times in a slightly different form. There was a lot of debate, discussion on this issue in the last few meetings. And we took a lot of those comments to heart, and some of those changes are reflected in this proposal here. We commend the acting director for accurately summarizing this petition, and we agree that the 100-word summary accurately conveys the proposal, and we ask that the board adopt it as is.
okay. Do we have any questions?
I
Ms.
do,
Hemming?
yeah.
Okay.
I'm sorry, I didn't catch your name.
David Porter.
Moore?
David Porter.
Oh, Porter, sorry. So my first question is, are you withdrawing the original then?
No.
Okay, and can you explain, because I don't understand, partially because I'm new, but I spoke to a few people who've done this for years and has never dealt with a situation where you have one that's been approved and then you submit another that's different. What is the purpose of having two different ones?
Well, as I said, we took a lot of the comments that were made at the last meeting and the discussion by the board to heart. Some of those changes are reflected in this new proposal, and so it just offers a different alternative in case we would like to proceed with that.
So you could potentially be circulating both petitions?
Correct, yes.
Okay. I still don't understand why, I guess. What's the, I mean, are you going to do some in some areas, some other, I mean, why would you take our comments to heart, which is good, but then not withdraw the one that you're amending?
I can't speak to that.
Well, can you see where that would give a board member pause? Because I don't understand.
Not to the question of whether or not the summary before you is true and accurate. No, I can't understand that.
But we've never had a situation as far as, and I might ask someone who's done this for years if you've done something similar, because I have not seen that.
Well, let me introduce you to Mr. Jacob. He's the
Okay.
head of the sponsoring group, and he may be able to add a little bit more insight.
Mr. Jacob, you have yourself also down to comment on this item, so we'll have both of you guys together if you would put your microphone on. And if you would state your name and spell for the clerk.
Paul Jacob, Pauljacob. I'm with Americans for Citizen Voting Michigan. We have not decided yet which measure we will go with. We're unlikely to do two. We're very likely to do one. This summary that we're discussing is on the measure that we think we're likely to go with, but we have not made a final decision. And by law, of course, we can propose and file as many measures as we would like. And I assure you, two is as many as we would like. But we haven't made a final decision. But
you are saying there will only be one at some point, and you haven't decided which one, or you haven't decided whether there'll be two?
I can't imagine any universe in which there'll be two.
Okay.
But we have not decided which one we'll go with yet.
Okay. So I have a few questions moving forward with this one. With some of the changes, so you took out some of the language regarding, let me see here. Bear with me for 1 second. References to state and local elections and federal elections and separate lists, even though some of that was included in the earlier one. And I still feel that information is needed because we are going to have, not only will we have separate lists, we're going to have separate ballots in this situation. So I'm wondering why you removed that from the earlier one.
This was the proposal, the summary proposal offered by the acting director. not us.
No, I'm sorry, I'm talking about the language in the your actual,
So the language in either this proposal or the one before you never referenced two lists at all. That was a hypothetical possibility that the board was potentially concerned about, and that's where that language came from. It is still only a potential possibility with this proposal as well. And in fact, it's even more remote because registrants, people applying to register to vote for the first time, do not have to present documentary proof of citizenship at that time, which was true for the other ballot. And so it is still possible for people on the QVF to present either those documentary proof or to submit an affidavit swearing that they are a citizen, providing other documentary proof of citizenship, and therefore comply with federal law.
but you did have language in the other one regarding state and local elections and federal elections, which are not in this new one.
You're referring to the summary or the proposal?
I'm referring to the proposal,
Okay.
and I'm wondering why you took that out, is my question.
Just to avoid any ambiguity between those various elections.
But, I mean, potentially, I know there is a potential regarding the list, but there are going to have to be more than one ballot, correct? You do agree with that?
No, we do
Isn't that
not
what's
agree
happening
with
in
that.
Arizona? There are different ballots.
This is, the Arizona law is not what we have submitted.
I understand that, but there are a lot of similarities between it. I looked at it, so.
We have built in a process in this proposal that can satisfy federal law. That is at least an issue that needs to be litigated, and no court has determined that this proposal would not satisfy federal law.
No court has spoken that much on this issue, period. A lot of this is very new, so that's not very persuasive, but I understand what you're saying. So another issue that, between the two that bothered me, and maybe you can help me figure it out, is, so the earlier version that we have already approved said that if a voter's citizenship is not verified before the voter applies to vote a regular ballot or applies to vote an absent voter ballot at an election occurring on or after November 2nd, 2027, the individual may only vote a provisional ballot and have 6 days to cure. I'm sorry, this is the new one, sorry. Your earlier one says that voters who are registering to vote up until December 8th, 2026, earlier version requires proof of citizenship when registering to vote after December 8th. This one actually hits right in an election and doesn't inform the voter, like the other one said, the Secretary of State must provide notice that citizenship is going to be needed. This one didn't in that section.
So I think, let me clarify, it's by the election on November 2nd, 2027, individuals whose citizenship has not been verified through any of the means in subsection 2, those are the individuals who need to vote by provisional ballot. That's the deadline that we're talking about, and that's what needs to happen by November 2nd, 2027. So it actually adds in, it ensures that there is a 10-month at least buffer zone for the Secretary of State to review the QVF and to send out these notices to individuals whose citizenship can't be verified or have been confirmed to be not citizens. During that time, those individuals can also, on their own volition, send in documents if there's any question or concern about whether or not they have sufficient proof of citizenship. So that's what needs to happen by November 2nd. It's actually a little bit more lenient and flexible versus the first one. And that's what we were referring to when I was saying that we took some of those proposals or comments to heart.
That's election day, so if people don't, November 2nd, 2027 is election day.
It is, yes.
So wouldn't it, I'm not sure that's going to allow.
You're referencing early voting, perhaps?
Correct. November 2nd is going to be the end of it. So if someone doesn't have it in by November 2nd, they're screwed. It should be earlier so people have a chance
Well, no.
to prove citizenship.
What you're assuming is that these individuals will not have been notified by the Secretary of State.
Well, and I do have an issue with that too, the 42-day. That is not enough time. So the whole notice issue where the Secretary of State gets, he or she will find out, right, that there's no citizenship verification. Then within 7 days of that, he or she sends a letter, correct, to the address that's on the voter file?
Correct.
And if the Secretary of State doesn't get something back in 42 days, then the voter's removed from the voter file. I think that is woefully insufficient, considering it can take me 15 days to get something from Detroit to Novi. I'm very concerned about people who rent, who move, who might not get the notice till 2 months later. I don't think that is sufficient in here. Or at least we have to put that in the summary where people need to be very aware that there's a 42-day limit where they might lose their voting rights.
So we shared that concern as well, which is why in subsection 7, we have an exception for people who can't get a hold of these documents for whatever reason. There's discrepancies on them. They can submit some alternative proof, including a sworn affidavit saying, I am a U.S. citizen, and here's where I was born, or something like that.
But
That's the
not sufficient
exception.
if you go to vote. I show up to vote and they say, I don't have proof of citizenship here. Then you get a provisional and you have 6 days to cure.
No, that is sufficient, because when they send that in, back to the Secretary of State within 45 days, then they are verified as a U.S. citizen and are eligible to vote and will not be voting by a provisional ballot.
No, I understand that. What if you don't get it back within 45 days? You didn't even receive the initial letter. That's my concern.
Well, there's a 90-day cutoff under federal law, which is, to
Okay.
conform with federal law, there's a 90-day cutoff before any election. That's the first thing. The second thing is 45 days, in our estimation, and I think reasonable minds can disagree on this,
Yeah.
is sufficient time to get something back to the Secretary of
I
State.
do not, yeah,
But
I'm
what-
sorry.
I-
I mean,
I do
I think for
understand your
those
point.
of us who are fortunate enough to own houses, who have had stable lives, who've lived the same place, and I've been fortunate enough. I know a lot of people who have not, who move a lot, who get kicked out of places, who still have a right to vote. And to me, it's not enough time. But that's just my opinion. So I would like to see something in the summary that at least makes someone aware that you're on a tight time frame, or you could lose your fundamental right to vote, which is really one of the most important things we have as a U.S. citizen. So the other one little thing, I know I have a lot, was in the old one, there was a requirement that the Secretary of State make reasonable accommodations to allow disabled individuals to present proof of citizenship, and it's not included in this one. And I don't understand why, or if there was a reason for that, or.
I think that's just subsumed within subsection 7, the exceptions.
Can you point?
Not expressly, I should add implicitly subsumed into that
Which is-
subsection 7.
If you have a hardship?
Correct.
Yes.
But hardship could, okay. I'm not sure to me, this seemed a little more draconian and had more chances where people could, I mean, my main concern is people losing the right to vote. I would hope that's a main concern of you too as well. And this seemed a little more draconian to me. That's just my view based on the few things we've discussed. Let me just check one last thing. Okay, I have nothing.
Thank you.
Thank you.
Thank you very much.
Yeah.
Mr. Cordes?
No questions.
No questions. I don't have any questions either, so thank you for your
Thank you.
input.
Thank you.
Mr. Jacobs, did we give you time to speak?
Yes.
You're good? Thanks. Ms. Reporter, I have to apologize for referring to you by the wrong name. I actually had a different slip in front of me as the represented attorney, so. Mr. Brewer?
Thank you, Mr. Chair. Mark Brewer of Goodman Acker, legal counsel to promote the vote action, which is a ballot question committee opposed to both of the proposals of the group calling itself Americans for Citizens Voting-Michigan. I first want to raise the procedural issue that I think has already been touched upon this morning. What's before the board is unprecedented. No group in my experience has ever not withdrawn a prior proposal and instead proceeded to ask you to approve two. There's been a lot of talk this morning about transparency. What's going on here is really hiding the ball from the public, because you just heard the testimony that, well, we want both approved. We haven't decided which one we're going to do. We may do one, we may do the other. They still could do both. This doesn't serve the public at all. And it just, again, I think an abuse of this process, an abuse of the courtesy that the board extends to sponsors to approve their summary. I just want to note that objection for the record. I hope it does not set a precedent for the future, or this board is going to be inundated with alternative proposals, and it's just going to get very, very difficult, not only for you, but for the public in Michigan to determine what's going on. As to the substance of this proposal, you have previously heard me testify on behalf of PTVA about our substantive objections. I will not incorporate those this morning. I will not repeat those this morning. I'll simply incorporate them by reference so that I can address the summary. The proposed summary does not meet the standards of 168.42B. That would be true and impartial. First, and this has already been raised here this morning, although this version of the proposal removed the reference to separate voter lists for federal and state and local elections in the prior proposal, there's still going to have to be separate lists, and the summary must disclose that. People are going to continue to use the federal form to register to vote in this state. Indeed, I would argue that if this proposal comes law, there'll be increased use of the federal form, because the federal form does not require that you provide documentary proof of citizenship. And so you're going to have an increasingly large group of people who are qualified to vote in federal elections, and this proposal can't stop that. And then this proposal is going to affect everybody else in terms of their eligibility to vote in state and local elections. So there are going to be two lists of eligible voters, and I think, as Member Cummings suggested, frankly, there's going to be two sets of ballots. For those that can only vote in federal elections, they'll get a federal ballot. For those that can vote in all elections in the state, they're going to get a complete ballot as they do now. So I think that needs to be continued reflected in the summary. There's also an inaccuracy in the proposed summary. New registrants are not required to present documented proof of citizenship. They can wait for the Secretary of State to verify their citizenship, or vote a provisional ballot if their citizenship isn't verified by the election, and then use the 6-day cure period. The language in this petition is particularly confusing and convoluted on this issue. The entire petition is that way as well, but this is particularly bad. As you work your way through this, there are really only two ways to verify citizenship, not three. The voter can present these documents before, on, or within 6 days of an election, or the state verifies citizenship. That's an accurate summary of what this is, and I think you can actually save a few words in the summary. To make these and other points, I'd like to share an alternative summary and work my way through it with you. May I tender an alternative summary, Mr. Chair?
If it's within your 5 minutes, you're good. You got 1
Can you
minute left, so.
Can you give me a break while I hand it to you?
I paused you.
Take every second I can get. To save time, I won't read it. It is 98 words. This version removes the second clause of the proposed summary because it is redundant of existing law, and the board's practice has been to focus summaries on what is new. Clerks already remove non-citizens from the QVF when they find them. And state law, statutory law, already requires clerks to give notice to voters when they are removed. So you can use those saved words to provide other information about the proposal. The first phrase, before the first semicolon, is more succinct than the draft summary. It's important to let voters know the type of documents they must present early on in the summary and not bury it later. The concept of matching the current name is vital, because as we've talked about before, there are going to be people, millions of people who are going to have name changes, and we're going to have verification problems. I would also note here on substance that Article 2, Section 16E of the proposal does not require the Secretary of State to accept name change documents. It says she may. Again, I think reflects very serious drafting problems with this proposal. I can continue if you'll grant me another minute or two, Mr. Chair.
Give you another minute to.
Thank you, sir. Phrase 2. First, I would note, as Member Cummings noted here, that this is an election date, 11/2/27 and 27. You're going to have two classes of voters in that election. Voters who vote early or vote by absentee ballot before that date are not going to be subject to this requirement. But on election day, if you show up, you are. It seems to kind of have a real equal protection problems, but that's a substantive comment. But again, this phrase we think is pithier than the comparable phrase in the draft and tells voters in plain English what's going to happen. They're going to be disenfranchised. Phrases 3 and 4 are the same, Mr. Chair and members of the board. Phrase 5, which begins necessitates separate statewide voter registration file, is the major change that I adverted to earlier. It needs to be continued in the summary as it was found in the first summary. And finally, in the last two phrases, we just made one change. It is violators who are subject to fines and imprisonment, not violations. And I think we need to make that clear. In sum, we think this alternative summary is more accurate, more thorough. We urge the board to adopt it. I'll be glad to take any questions. And thank you for your indulgence, Mr. Chairman.
You're welcome. Mr. Cordes, do you have any questions?
I do not have any questions.
Ms. Cummings?
I do not.
No questions, but I would like to just, the point that you made when you first started out your discussion, your period, you made the point of the threshold we're crossing by having multiple petitions for the same thing submitted. And Mr. Fracassi, I've heard your responses on that in conversations we've had as well. That just to note that I agree that having multiple petitions is very unusual. So thanks for bringing that out. And
More than unusual, Mr. Chairman, unprecedented, and I'm very worried about what's going to happen to this process going forward.
Can I ask how long you've been doing this?
I've been practicing before this board since the 1980s. This process is newer than that. But I have never seen anybody, and I would not advise my clients to do what is being done here today. I just think it's poor practice and doesn't serve democracy to hide the ball in terms of what proposal a group's going to circulate.
thank you for your time.
Thank you, Mr. Chair and members of the board.
Before we're going to do general comment as well, but before we do, I have a question. Mr. O'Keefe, you are an attorney, correct? I am. You are, but you are limiting. You are only for number 6, which is the form. Well, there's some confusion as to which one you wanted to speak to. So, do you want your 5-minute to be here? No, not right now. Okay, then I'll bring you back up. All right, good. It is O'Keefe? I'm O'Keefe. Yes, that's okay. I have to say, I don't think it's
Of course.
There we go. We have a couple of general comments requested. Shelley Lake. And would you state your name and spell it? You know the drill, right?
My name is Shelley Lake, SHELLYLAKE. I want to thank you for allowing me to speak. I'm a deputy clerk in Berry County and am in support of this initiative. And I do like a couple of the changes that they made. I like that the fine and the imprisonment possibility is in there. Even though it's the law, you have to be a citizen. I like that it's in there. I also like that a little bit more lead time was given to allow the Secretary of State to prove this citizenship for people. The best part, I think, is the state-funded hardship program, because not everyone can afford to pay the money to maybe go get their birth certificate. So I really, really like that part. I just hope that you will approve this, and I have no doubt that they will choose between the two and file only one on the ballot. Thank you.
Thank you very much. Your review, timing was perfect. Darlene Hennessy. And would you state your name and spell it for the...
My name is Darlene Hennessy, Darlenessy. I'm here speaking on behalf of Michigan Fair Elections Institute and Pure Integrity Michigan Elections. Thank you for the opportunity to speak. I firmly support this proposed constitutional amendment to strengthen the integrity of our elections by requiring the Secretary of State to track the citizenship of all voters and secure a statewide program. Sorry, my printer didn't work. I have to read off my phone. I'm not following this well. Okay. This ensures only eligible United States citizens will be able to participate in our elections. It prohibits the counting of ballots from citizens who cannot verify their process, the proper documentation. It will restore more trust in our elections. There's been a lot of problems lately of people not trusting elections, and so we just think that this proposition would be something that would restore trust. Thank you.
Thank you very much for your comments. Mr. Jacob, I'm going to invite you back up here to make your own comments and also point out that you are the sponsor of the petition. Is that correct, sir?
Yeah, I'm part of this.
This is yours. Okay.
Kurt O'Keefe is our treasurer.
Okay. I
Yes.
think you've already stated your name, and I think you're okay there, but
Yes. I would just say, I think the 100-word summary, we could pick at this word or that word, I think it's accurate. This idea that there'll be two lists, I think is made up. We've made changes that make that not likely at all. And I think the idea of deciding to put into a summary what we think will happen in the future if there's litigation is a fool's errand and is not what the summary should be. They should be what the measure does, not what somebody thinks might happen because it passes. And in the interest of time, I'll just close by saying in Michigan, in 2024, there is absolutely no doubt that non-citizens were able to vote. The system did not work. We ought to be able to verify whether someone is a citizen in order for them to vote. It's not rocket science. It's not always simple, but it can be done. And I believe this proposal is the best proposal yet made to do it.
thank you, sir. Stay right there a sec, would you? I'm gonna, because you are the sponsor of this petition, if it's okay with you, I'm going to invite my colleagues to, if they have any questions, to ask you those. Do you, Ms. Cummings?
No, I don't.
You do not. Mr. Cordes?
I do not. Look forward to hearing Adam walk us through his 100-word summary.
I think that we're good then. I have no questions for you either.
Thank you very much.
Thank you. And with that, Ms. Fracassi, would you walk through the summary?
Happy to. So I'll kind of walk through why, and then I'll respond to some of the things that I've heard as well and some thoughts. So I'll work my way through clause by clause, because I think that's an easier way to kind of go through it. So that first part with requiring secretary to verify and track voter citizenship through this program, as I read the constitutional amendment, section 2 in the constitutional amendment specifically says you have to verify citizenship one of 3 ways. First being that the Secretary of State administers this citizenship verification program, in which we're looking at specific records in order to prove it on our end. And then the second way is if an individual voter does provide proof of citizenship to an election administrator, being like it could be our office, it could be a local clerk. So that was why so that's kind of that piece there as well. And then the third is during this provisional ballot period, where if somebody does not, if someone's citizenship has not been verified and they have to vote a provisional ballot and they provide their documentation during that provisional ballot period, then that's that way of verifying citizenship. So it's those 3 ways as I read that subsection 2 in the proposed constitutional amendment. The next piece regarding the removal of non-citizens after a mailed notice, I do agree generally that the practice is to not include things in the summary that we've already discussed. The reason I kept that in specifically was because it intertwined with this verification program. And so to me, I was looking at this as a new requirement in that sense, because what I read the constitutional amendment as requiring is the secretary has to administer this verification program. If we, during the course of our review, if there is an allegation that somebody is not a citizen, if we've reviewed documents, we can't prove it, then we have to mail them a notice saying basically, we're removing you, and then you have that 45-day period that Member Cummings was talking about to respond to that. So relatedly, I don't interpret the constitutional amendment as requiring the secretary to mail notices to everybody, period. Like if we haven't verified it, but so I think that notice period is limited, or that notice is limited to if we've removed it. We do have to provide this in section 2, this notice on a regular basis, as that term is defined here. I shouldn't say defined, but as that term is presented here in subsection 2. We provide on this regular basis that their citizenship has been verified, or for folks that are already registered, when their citizenship is verified for voter registration purposes. That's the specific text in there. But there's no, I don't interpret any requirement if we haven't gotten to you yet, for example. So if you're in that like middle ground. So you've got a notice for folks that we have verified. You've got a notice for folks that we are potentially removing, and then nothing in between is kind of how I'm reading this notice. So that's why I kept that notice part in here to say we're removing non-citizens after we provide a mailed notice, to also show that folks now are going to have to take another step as well. So it is true that clerks currently do remove for citizenship reasons, and the Bureau of Elections removes for citizenship reasons as well. But now what's new is that there's going to have to be this mailed notice and an opportunity to respond. And so that's why I kept that notice piece in there. I do hear Member Cummings' concerns about wanting to put like a time frame in there. If we want to put time frames, I would actually put it there and say something like remove citizens after mailed notice and 45 days to respond, or something like that. And obviously not the best words, but I would kind of tie the time frame right there with that notice piece. The next part of the beginning November 2nd, 2027. That is, I think it's pretty self-explanatory. It is effective with the November 2nd, 27 election, that if you have not demonstrated citizenship in some way, if a voter has not demonstrated citizenship in some way, or if the secretary has not gotten to you yet, then you have to vote a provisional ballot and provide some sort of documentary proof of citizenship, as one of the, as Section 6 provides the list of it. We've kind of gone through some of those already. The next clause for new registrations, I'll be honest, is me probably not successful in what I was trying to do. What I was trying to do with that was tie it to this provisional ballot period to say that if you're a new registrant and you have not provided anything, any sort of the proof of citizenship as listed in subsection 6, then you are going to have to provide that at some point before you are allowed to cast your ballot, cast a regular ballot, I should say. I am perfectly fine with kind of tweaking that, and I think it should actually be adjusted to make it a little bit clearer with what I was doing, what I was attempting to do.
What sentence were you?
The 4 new registrations require proof of citizenship. I unsuccessfully tried to tie that with the clause before, and I'm saying that because I heard testimony of folks, so that tells me I wasn't successful in what I was trying to get across. So I am perfectly fine with changing things with that to tighten that up and make that a little bit clearer with what I was trying to, with what the point of that section is. The point of that piece is to say that in order to prove citizenship, you have to provide one of these things, period. So I think you can drop the new registrations, the 4 new registrations, and just say the rest if you want. You could move that up and say we have to provide this citizenship program, and that includes providing proof of documentation in some manner. I think the next piece is self-explanatory. The rest of the pieces are self-explanatory as far as the requirement for providing your driver's license number or partial social security number in order to vote absentee. Again, we kind of phrased it that way. I kept this phrasing from before because it's all steps of the absentee process. Do you have to provide some sort of identification requirements? And then same, or a copy of the driver's license itself, your photo ID. Or some other election ID that meets the requirements. And then same with the next 2 with requiring a fund hardship program and then subjecting violations to the penalty. So in terms of some of the comments that we've heard, so I've kind of addressed that notice of removal piece. And I also addressed that new registration piece. The other one that I heard is violations versus violators in that last line. I think that's fine if we want to make it violators. It probably is a little bit more accurate and precise to say subject violators versus violations. So I'm fine if the board wants to make that switch. I want to talk about the separate lists provision. We had a long discussion about this at the last one as well. So the struggle that I have with this is I cannot sit here and tell you today that we will have to have 2 separate lists. What the text of the Constitution does require, though, is it does mandate that we have to specifically call out the citizenship status in the qualified voter file. I don't know sitting today if that can be done in one system, if that's going to require a new system. I don't know today if that's going to mean we're going to have multiple versions of ballots. I don't know if there's going to be a change for tabulators that would allow, or I don't know any of that piece. So that's why I still struggle with putting anything in there that says like mandate we maintain separate lists or mandate 2 separate ballots or 3 separate ballots or whatever the number is for that reason, because I don't know what is going to, how we would implement that requirement. But that is why I retained the track citizenship at that beginning, because we did talk about that last time and kind of settled on it would require us to track citizenship in the qualified voter file. So that's why I kept it as verify and track all voters' citizenship through a statewide program. I think that is pretty, that's all the comments, I think, and the suggestions that I heard on substantive with the summary language. So, but with that, I'm happy to answer any questions or hear any suggestions or anything that the board would like.
So one thought with the tracking, the two lists or, the issue with, oh, sorry. So the original summary had language saying, document citizenship, hold on. Oh, yeah, remove non-citizens and track separate eligibility requirements for federal and state local elections. That was in the old one, which I do think might solve that issue.
Yeah, we can tweak if we can. I think it is still accurate to say track eligibility because of the kind of the existing state of the law. And that is also what the Constitution says. The proposed amendment, says.
Right.
So I tried to do that just by moving it up to the beginning, just to say verify and track citizenship. If we want to add some words there, I think we probably could, but obviously we're at 100, so something would have to come out.
I just think it is going to cause two separate, if someone goes in and registers via the federal form, that isn't going to be sufficient for the state to be eligible to vote. So there's going to be a separate, whether it's a list or, there's definitely going to have to be something separate.
There has to definitely be some sort of separate flag.
Right.
In some capacity somewhere. That is mandated by the plain text, to be honest. So I think it is accurate to say that there has to be some sort of tracking in some flag.
Yeah.
Like I said, I don't know that the details, like the specifics, if that would mean a whole separate quote unquote file or what. It almost seems like based on the text, we wouldn't be allowed to do a separate file. We would have to somehow like track this in the qualified voter file as well. So I don't know if that answers your question.
Yeah.
Okay.
Okay. Are you?
Yeah, I was going to ask Mr. Cordes if he has a...
No, I mean, we've litigated the list thing at length, and I have also went back and looked at, we landed on that language of separate eligibility requirements for federal and state elections. I obviously know, it'd be very tough to add that into here. If there was a way to do that, I would be fine having that added in there rather than, I vehemently oppose to putting in, lists and confusing people with lists, but I do think that when we added that in, that was a clear way of defining that there is some separate tracking that occurs there. So I don't know if there's a way to condense that down even more, but I would be fine if that would, if that helps you get there and by adding that in.
I think there's some things we can delete. I mean, if we start moving stuff a little bit.
I think we can. It seems to me that if this is on the ballot and this passes, it's going to have a significant impact on local clerks, county clerks, township administrators, not to mention the election workers at the ballot box. Whether you call them separate lists or not, this is going to require an election worker to know what rights you have as an individual to vote on specific elections beyond what they have today. Is that?
And it's going to require some sort of tracking, right? Like, so not only just in the QVF, but it's going to have to require some sort of notification in the qualified voter file, like it says, but also in the poll book, both at the early voting sites and at the election day polling places as well. Because if somebody, let's say my citizenship hasn't been established yet, one way or the other, and if I show up on election day, there's going to have to be some sort of indication so the poll workers and the local clerks know that I need to be issued a provisional ballot, or if I return an AV ballot and if I put everything on there, but my citizenship hasn't been verified, there needs to be a notification to the local clerk that the AV ballot has to be treated as a provisional ballot. And then there's going to have to be a notification to me to give me that time period to cure the provisional ballots and to provide the information. So there definitely is going to have to be some sort of change with the QVF, with the poll book, with the lists that get established, with the poll lists, I should say, that get established before the election, so.
Well, and again, it goes back to, I don't know how we would ever manage to put that in the 100-word summary, but the tracking and verification on the Secretary of State level is one large entity. That's a lot of changes that have to come. But again, the complexity of walking in and casting your ballot for both the election workers and the local election officials and the voter themselves. And I don't mean to be talking sideways. I should be talking towards you, forgive me. There's no room to put that in a 100-word summary, but I think that's also very relevant to what we're talking about.
Yeah, that's why I think it's important to show there's two, whatever language we land on, which if we've already agreed to the earlier phrase, I don't see why we can't include that. There is definitely going to be a change for election workers and vote for everybody involved in elections and voting.
I'm fine trying to figure out a way to put that, to make that clear, like the language that you read, that we discussed, that the board discussed and approved at the, what did we say? I already forgot. May 16th meeting? Thank you.
Yeah.
Yeah, and trying to figure out a way to add that in.
So if we're going to move forward now, and we're going to work with how to, with what edits here, what revisions to put in the 100-word. Do you want to go back to the way we did this earlier and break this actually into sections and just approve off the sections we know we want? Or do you want to take it top down? How should we approach this?
Would it be helpful if I try to take a shot at like adding in, I hear the 45 days, trying to figure out a way to add in timeframes and try to figure out a way to add in back that tracking requirement? Would it be helpful if I did a draft of that first, or?
Suppose if we took like a 10-minute recess, because I think some folks need to do that anyway. If we took a 10-minute recess, would that give you enough time to weasel words some stuff?
Maybe.
How about if we try it?
We'll find out.
We're going to recess for 10 minutes.
Take 30 seconds.
I'm sorry?
30 seconds.
30 seconds before we go into recess. Does this have anything to do with?
Yeah, Kurt O'Keefe, Treasurer, American Citizen Voting, Michigan. Just in terms of, there's no objection to, Mr. Burr pointed out, putting permit instead of require proof of citizenship, and no objection to violators instead of violations. And in terms of multiple petitions, I would point out that the board has already approved 2 separate citizen-only voting petitions. It is an anomaly, and it's something that is not ideal from anyone's point of view. But the idea that this will open floodgates, I think, is beyond far-fetched.
We're going to go into recess until we will.
Two different groups, not 2 from the same group, right? What am I missing in what you're saying? When you say 2 separate ones, that was your
There's
group
2
and a different group.
I understand that. So in the law business, I would say that's a distinction without a difference in terms of the points were raised that there's more than one citizen voting that's already been approved. So as far as it's confusing the voters or doing this or doing that, I think that in the end, no matter what happens, that there will only be one of the 3 that have been submitted that will actually happen. It just makes no sense otherwise. So I don't envision that it would happen.
We are in recess until 12:05. Thank you.
I know he had to go.
Okay. Ready to go forward? I'm gonna ask you to read this a minute. Mr. Acting Director, would you read the new 100-word summary for us?
Yes. Yes. Thank you. I was trying to find my pen. Sorry about that. All right.
You want to use mine?
I got it, thank you. It was just buried under the paper. So this is the, after hearing everything, this is the updated language. It's being distributed to the audience now as well. So it reads as follows. Constitutional Amendment 2 requires citizenship verification for all voters through statewide program, document submission, or provisional voting. Require removing non-citizens after notice and 45-day rebuttal. Require proof of citizenship by showing birth certificate, passport, and/or other documents. Track separate federal and state/local election eligibility requirements. Beginning 11/2/27, prohibit counting ballots from voters with unverified citizenship unless documents shown to election administrator within 6 days post-election. Eliminate affidavit alternative for voters without photo ID. Require photo ID or driver's license or partial social security number to vote absentee. Require state-funded hardship program for obtaining required documents. Subject violators to $1,000 fine and/or up to 5 years imprisonment. That is 100 words exactly. So a couple of things, if I may, I'll kind of like walk through what I did. So we did add in the tracking separate eligibility requirements and the 45-day notice period. Phrased it as 45-day rebuttal to try to save some words, to be frank. I did at the very beginning, one of the first things that's different is I did remove the require Secretary of State to verify and track all voter citizenship, et cetera. The reason I did that is because by switching this around a little bit and having the provisional voting and things like that in there, I don't think it's 100% accurate to say it requires the Secretary of State to verify citizenship through provisional voting, for example, because that's going to be done at the local clerk level, not at the Secretary of State. If you if you have to vote a provisional ballot and that has to be cured, the amendment requires that it be done either at the Secretary of State's office or the local clerk's office. So that's why later I specifically called out shown to election administrator, because that could be city, township, county clerk, depending on who's running the election, depending on like what's the situation. So that's why I phrased it that way. That's why specifically I also removed Secretary of State at the beginning. I did slightly tweak the track separate federal and state/local election eligibility requirement. Can I borrow that if I may? Yeah. The difference between the two, I just heightened it slightly to save a word. Previously, we had track separate eligibility requirements for federal and state/local elections. So I just adjusted it to say track separate federal and state local election eligibility. We were able to save one word. One word matters in everything. And then I flipped the November 2nd, 2027 and just used a date format, the 11/2/27 to save a word as well. But in general, added in, so I'll kind of summarize it real quick, added in the two clauses I heard the board want with the tracking eligibility requirements, added the 45-day rebuttal in, and then removed the Secretary of State specifically, that language, and then switched violations to violators at the end of it as well, and it is 100 words exactly.
Nicely done. Mr. Cordes, have you got any questions?
I do not.
Comments? Are you good with what we have here?
I am.
Ms. Cummings, questions, comments?
I'm good.
You good with what we have here?
I am.
If we are good with what we have here, I would say, I would certainly entertain a motion to go forward.
Yep.
I move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by Americans for Citizen Voting, Michigan, as drafted by the Acting Director of Elections and presented by the Acting Director on July 10th, 2025.
Do I have a second?
Second.
Moved and seconded. All in favor?
Aye.
Aye.
Aye. Excellent. We have a 100-word summary. Moving on to item number 6, the consideration of the form of the second constitutional amendment submitted by Americans for Citizens Voting, Michigan. If you will let me get my list here. Mr. Porter.
Thank you. We don't have any extended comments. We would just ask the board to approve the form subject to the replacement with the summary language that you just approved moments ago.
Nothing else? All right. I don't believe we have any separate public comment for this item. Mr. Jacobs, you don't need to. All right. Excellent. And Mr. You have reviewed you've reviewed the form.
Yes, staff has reviewed the form. Again, same caveat I always give, we don't look at the back with the language for approval as to form, but obviously this one has changed from the petition that we previously approved, the form of in agenda item number 4, as well as a summary. So this would be conditioned upon, the form approval would be conditioned upon replacing the summary language at the front of the petition as well as the backside of the petition as well. Beyond that, staff has reviewed the other form requirements and determined that it met the requirements and the standards.
Perfect. Before we move on this one, though, I'd simply like to, for the American for Citizens Voting Group, 2 petitions is, I think I'm speaking for conversation we've all had up here. Doing 2 petitions for the same petition is not a practice that should even come before this board. So, I mean, I'm kind of calling you out a little bit on that. I think you understand that. We don't want to become the Walmart of petitions. And the precedent you're setting is a dangerous one. It's not a good one. That's why I'm having this conversation with you. There's no chance that you would consider recalling one of them, is there?
Not today.
Not today. You know, we're having a meeting next week.
Yeah.
You're having so much fun, you're coming back next week.
We're coming back next week, but I would seriously urge you, just as having 2 of them out there does not set a good example for the petition process. So now the other comment I would make to you is our appreciation, because it looks from your second one like you took some of the commentary and some of the conversation that we had, and you took it to heart, and you actually crafted your second petition with consideration for that, and so you have our thanks for that.
It's highly likely that your concern will be met in the next week in a way that you find appropriate on the 2 petitions.
Okay.
How's that for a lawyer?
I like that answer. That's a good lawyer's answer. All right, and with that, go ahead, I'm sorry.
One more thing I forgot to mention, just as a reminder as well, with the board changing the sampling process as well, we do not separate at the front. So I just want to, I want to just kind of give a quick reminder of how we review the petitions, because if 2 are circulated, the effect that will have. So prior, what we would do before is we would comb through and we would separate the sheets out, as you might recall, kind of what we would call calling the universe, basically to find a universe and then do the sample. When it comes in, we will just pull the sample directly from whatever is filed. And if there are multiple versions of petitions in that filing, the Bureau's practice, obviously subject to the board, is we treat that as the same requirement. You know, there is that requirement under 483A of election law that it has to be filed with us before it is circulated, before it's allowed to be circulated. The as circulated version, if we see signatures that are before that filing, if we see a sheet that's before that filing, if we see multiple sheets in the sample of multiple different petitions, those are rejected and it's extrapolated out. to the rest of the filing under the established sample procedures. So I just wanted to flag that and as something to be mindful of and be aware of. So, thank you.
No, I appreciate you making those remarks and adding those to the records, and that's certainly something that would also affect you, not in a good way, I might add. With that, do we have a motion?
Yes. I move that the board approve the form of the constitutional amendment submitted by Americans for Citizen Voting, Michigan, conditioned upon the replacement of the summary language approved by the board today, with the understanding that the board's approval does not extend to, 1, the substance of the proposal, which appears on the back of the petition, and 2, the manner in which the proposal language is affixed to the petition.
Do I have a second? Support. All in favor?
Aye.
Aye. The form is approved. We're on to item number 7. Is there any other business that needs to be presented to this board before we call it a day? Perfect. We're adjourned. Do you need a timestamp on that?